Good morning and welcome everyone, and thank you for joining us for Kirby Center's financial presentation, part of our ongoing presentations on health and wellness, education, information, and entertainment presentation series. And today we're looking forward to some information that is going to help us with our financial planning as we move forward. As we gather here today, it's vital we remember the peoples who've gathered here for millennia. This is the Treaty 7 land of the Indigenous peoples of Southern Alberta, the Blackfoot Nations of Siksika, Piikani, Kainai, the Tsuut'ina First Nation, the Stoney Nakoda Nations of Chiniki, Bears Paw, and Wellesley, and the historic home of the Northwest Métis and Métis Nation of Alberta Region 3. The past 9 months have been a particularly difficult time for our seniors, and many of you, in addition to maintaining your good health and navigating through isolation, have had real financial concerns. With the current economic climate, retirement investments may not be reaping the returns we hoped for, or causing worry about our economic future. We hope that this series of presentations, we can help to provide some answers to put your mind at ease. Today, we welcome Kirby Center's Director of Fund Development, Rob Locke. Rob has been hosting financial presentations at Kirby Center regularly for the past several years, and now joins us in providing this information to our members virtually. And he's here to tell you about the program. Welcome, Rob.
Thank you. Thank you for joining us today for our wills and estate planning presentation. We are pleased today to welcome Jonathan Ning. Jonathan practices at Underwood, Gilholme Estate Lawyers, a group that works exclusively in estate matters. He assists clients in the preparation of wills, enduring powers of attorney, personal directives, and trusts. He also advises executors and attorneys on the administration of estates. In addition to his experience making court applications for grants of probate and administration, he has appeared before the Court of Queen's Bench on applications for the validation of non-compliant wills and family maintenance support. Over the past few years, Jonathan has provided seminars at Chinook Learning Services. He's done many presentations at Kirby Center over the last 4 or 5 years, and the Canadian Association of Gift Planners. He has appeared on CBC Radio to discuss the importance of having a will and on estate topics. Jonathan is a member of the Canadian Bar Association, Southern Alberta Wills and Trust Sections, and the Estate Planning Council of Calgary. Jonathan, tell us why it is important for each of us to have an effective end-of-life plan. Welcome.
Thank you, Rob, and thank you, Colleen, for the warm welcome and for hosting me today. Looking ahead on time here, I just wanted to let everyone know that I'm shooting to complete a formal presentation by around 22 or 15 minutes before the end of this presentation, so we can address some questions. And the big question on everyone's mind, and Rob set me up here, is what is the importance of having a will? And that's going to be our big question and big topic today. So to save everyone from having to look at my face for the entirety of this presentation, I'm now going to switch to a set of slides. And I believe you do have the option of keeping a mini version of my face in the corner if you want to see all of my gestures and reactions. Otherwise, feel free to direct your attention to the slides that I'm going to share now. And maybe I'll, because I can hear Rob and Colleen, I'll ask for your confirmation that they are on the screen now. Thumbs up. Do you see them okay, Rob and Colleen?
Yes, I can see it. Sorry, I had to move there.
Very good. Okay, so this is where we'll start. We'll hit the ground running. Again, thanks, Rob, for the warm introduction. Here we are, wills and estate planning. So the first thing we're going to talk about today is what is an estate. It's a term that's used commonly, and it's very important for our presentation today that we define what your estate is. The big question on our minds, do I need a will? And what is the importance of having a will or an updated will? The big thrust behind having a will is making choices, empowering ourselves with choosing executors, beneficiaries, and many other choices that come with preparing a will. And finally, if we have a little bit of time, we'll talk about the companion documents that come along with a will. Here in Alberta, they are known as the enduring power of attorney and personal directive. This is what's known as incapacity planning, planning for a situation where you may be unable to make decisions on your own. In the event that we don't have time to cover those two items, I do have some slides and some material for you to consider further. So what is our estate? Well, big definition here, the estate or your estate is the sum of your assets and liabilities owned by you at any point, whether you're alive or at the time of your death. So everyone that's listening here today has an estate. It is the sum of your assets and liabilities. In the context of today's presentation, we always ask ourselves, what is our estate at the time of our death? Okay. And the questions we have to ask ourselves first when we examine our estate planning is what falls inside of our estate upon our passing and what passes outside of our estate upon our passing. So let me give you a little diagram that'll give you a better idea of what I'm talking about. So if I was to put my estate assets inside of this box here, property owned by me, debts owned by me alone, that is what we define as my estate, okay? And I suppose maybe to share a little bit further with our group today, I'll give you some information about me. Assets that I'll put inside this box might be my bank account, that's in my name alone, my vehicle registered in my name alone, my clothes, which I'll put inside of this box, they're all mine. I don't share them with anyone. No one would fit my tiny suits anyway. Let's see here, my computer that I'm speaking with everyone on today. Those are all part of my estate, assets owned by me and me alone. Now I'll give you examples of some assets that are outside of my estate. And as I give you these examples about me, you can consider a little bit about your circumstances. But before I give you these examples, more information on me. I am married and my wife and I have 2 kids, and that is relevant to this conversation. So here we go, assets outside of my estate, jointly named or jointly owned property and bank accounts. So my wife and I, we own our home in joint names and we have bank accounts in joint names. I have RRSPs. Some of us joining us today may also have RIFs, tax-free savings accounts, life insurance proceeds, pension benefits. These are all assets that are classically referred to as outside of our estate. So what happens, using myself as an example, what happens if I pass away? Starting with the assets that are outside of my estate. So let's look at that jointly named property and bank accounts. If I was to pass away, the surviving owner, the surviving joint owner of my bank accounts, the surviving joint owner of my real estate becomes the automatic owner of that asset. Be mindful, this happens without a will. So to be more specific on my example, if I was to pass away, the home that I own jointly with my wife automatically becomes my wife by way of joint ownership. And the same goes for our joint bank accounts. And that's without a will. Next, my RRSPs. I have named my wife as my beneficiary of my RRSPs. And if anyone has named beneficiaries of their RSPs or RIFs, those named beneficiaries or beneficiary receives that asset without a will. The same goes for tax-free savings accounts, life insurance proceeds, and pension death benefits, if any. Being mindful, some of us receive pension benefits on an ongoing basis. From time to time, there will be a death benefit on death or some commuted value of the pension. And if it's an opportunity to name a beneficiary, that beneficiary receives that remainder pension benefit or life insurance portion of the pension. So what I'm picking up here, or what I want everyone to see, is that there are many types of assets. And there are 2 sort of categories when we plan our estate. Assets that are inside our estate, we'll get to that in a second, and then all these assets outside of our estate. And I'll encourage everyone there that's listening out there to be mindful of where their assets stand and whether there are joint owners on some of these assets and whether there are beneficiaries attached to some of these assets. Now, zeroing in on the box in the middle, property owned by you alone, this is your estate by definition. And we'll spend some time now talking about what happens to these assets, the estate assets, upon death. We'll speak briefly a little bit about what happens if you don't have a will. I think considering the situation where people don't have wills allows us to appreciate what it means to have a will. So the term for a situation where there is no valid will is called intestacy. Intestacy. Under this circumstance, there is a provincial law that sets out who receives your estate assets and who has the right to administer your estate. That's known as an administrator. I don't want to spend too much time here today because we're talking about planning wills, not talking about what happens if you don't have a will. But the key takeaway here for everyone is that if there is no will, there is a default law. There's a default will, so to speak, under the provincial law that sets out how your estate is administered and who's in charge. Now, for some families, this default law is unacceptable and they want to do something different. Consider this: if you don't have a will and it is your wish to benefit friends or charities or maybe distant family members, they will not be considered in the distribution of your estate if there is no will. To be brief on the matter, the rule or laws of intestacy state that only close family members share in the distribution of your estate, starting with spouse, children, grandchildren, parents, and so on. There's sort of a pecking order on how this works. I don't want to bore you all today with how that operates, but again, the takeaway here is that if you don't have a will, there's a default will. And for many people listening today, that default will is probably not to their satisfaction. So what does a will do? Well, first and foremost, a will gives us power. It empowers us all to make decisions regarding our executor, guardianship for minor children, beneficiaries, who benefits from your estate. You can create trusts in your will to protect maybe vulnerable members of your family or vulnerable beneficiaries. And finally, charitable giving is a big part of many people's estate plans, and we'll talk about that today. Now, there's a little asterisk there. We'll talk about that in a moment, but this is talks a little bit about will challenges. So we'll see if we can spend some time on that a little later. So willpower. Let's spend the bulk of our time here. Choosing your executor is the first decision in preparing your will. This is the person or persons who will oversee the administration of your estate, carry out the terms of your will, and I like to tell clients, essentially pick up a part-time job for the better part of 2 years. Some of the key duties of an executor start with arranging a funeral. For those of us that have been involved with this before, either as an executor yourselves or lost a family member, planning a funeral starts immediately. There's a saying, it's certainly not mine, but there's a cliche that says planning a funeral is like planning a wedding, except in a week. So consider who in our lives do we entrust with this type of responsibility? And this is a hint for later, but what type of wishes do we want to leave for them so that this planning process isn't too much of a burden? After funeral matters are dealt with, the executor moves very quickly towards finding your assets and gaining control of your assets. I use a phrase here in the slides, obtain legal title to your property. That basically means, in fancy legal speak, finding your stuff. They need to find your stuff. They need to know what you own. They need to know where your property is, where you bank, where you might be receiving pension benefits, where your investments are. Right? If you operate a business, the matter of being executor becomes even more complicated because now they run your business potentially. So obtaining legal title to your property can be a complicated matter. There's a comment here on the slide saying that something called a grant of probate, or essentially permission from the court or an order from the court, might be needed in order for them to gain control over your assets. And it's wise to obtain legal advice in that regard. Paying your debts, paying income taxes, and of course, generally paying for any of the estate administration expenses is part of the executor's duty. I'm commonly asked, does the executor have to personally pay for your debts, or personally pay for your taxes, or personally pay for your estate administration expenses or funeral matters? The short answer is no. Your estate, your assets are responsible for paying for your debts, your taxes, but the pressure's on to make sure that that executor is using your assets carefully and applying them towards debts first before paying shares to beneficiaries. We'll talk about that in a moment, but I want you to recognize that executors are not responsible for paying your debts, but they have to be very careful that they use your assets wisely. The distribution of your estate tends to be one of the final stages of an estate administration, that is giving your assets to the people that you have chosen in your will. And finally, we'll talk a little bit about trusts later, but sometimes an executor is also asked to be the trustee of ongoing trusts that you set out in your will. This is when the 2-year job of an executor could become a 5, 10, 20+ year job for your executor, as if you ask them to be a trustee. More on that a little later. So as we contemplate somebody in our lives who can be an executor, now pondering some of those duties, what are the qualities of someone who would be a good executor? Well, certainly someone you trust, It's possible to ask more than one person to be your executor. So a common way to do it is to name one person as an executor, but if they cannot do the job, or if they're not willing to do the job, you name a number 2, a backup person, right? I'm jumping ahead, but that's the idea of naming alternate executors. You'll see that in your slides. It's possible to name 2 people, or 3, or 4, and so on. Many people to be your executor together. Generally not my advice. Consider this, there's a reason why companies have one president, not co-presidents or co-co-presidents and so forth. Administering an estate is like operating a company. Many decisions need to be made over this 2-ish year long period. And it's wise, at least for decisive reasons, to have one executor. Many families say to me, I get it, it's convenient, it's decisive to have one decision maker, but I have 2 children, 2 capable adult children. They get along, they like each other, they live near each other, they see each other socially, they complement each other. Well, these are indicia that tell me that, okay, maybe 2 executors makes a lot of sense for this particular family. But let's see where consider a situation where that might not work. What if these 2 adult children don't get along? Asking them to be co-presidents of a company for a 2-year period just might be a disaster. What if one of these executors lives very far away, perhaps in the United States or overseas, or even out of province? That could be complicated. Administering an estate for many estates is a very local exercise. Here's where your home is. This is where your bank accounts are. This is where your life insurance broker is. It's convenient, certainly, to have all your executors here in town. Not impossible, especially in this day and age where we're all connected over the internet. There are great ways for an executor to administer an estate remotely, but be mindful of some of the complications if an executor is out of town. I do want to press upon everyone here today the importance of joint executors who get along. It really is, in my experience, one of the more complicated areas when we have joint executors, and families should think very carefully about choosing or asking 2 people to do a job together. Do seek the approval of your executor. For those of us that are rewriting our wills or preparing our wills, do check with your executor. They might tell you something that might surprise you. They might tell you that they're not prepared to do this for you. They might tell you that they might not have the time to do this. Don't be hurt by this. They are doing you a favor by telling you that they're not going to do a good job, or they're not willing to do it, or not prepared. So do seek their approval. And finally, there's a comment here: choose someone younger than you. That is generally good advice. Certainly, that gives your will shelf life if you have someone younger than you. But there is nothing wrong with appointing an executor who is a contemporary and is in good health, of course, and willing to act. But do consider naming alternate executors if that particular person is not able to act for you at the time. I'll talk very briefly about guardianship for minor children. We may have some participants here today who have minor children or minor grandchildren. So a will is an opportunity for the parents of these minor children to name the parents or the guardians for these children moving forward. So my wife and I, our children are quite young, so writing a will for us is very much highlighted by choosing guardians. May or may not be the case for everyone here today, but certainly something to be mindful of when preparing a will. So I won't spend too much time on this slide, but I do outline some of the traits of traits of good guardians and considerations when choosing guardians for minor children. Bequests. That's a fancy term for a specific gift given through a will. What do I mean by a specific gift? Well, a will can say, and I'll use this as an example from the slides, to my nephew, Isaac, my entire Coca-Cola bottle collection. So be mindful, I've identified who is receiving and what it is he receives. This can come in the form of a cash gift, $1,000 to each of my grandchildren, right? Just a comment for someone considering a will that gives a cash gift and makes reference to grandchildren broadly, it might be wise to name them individually. Perhaps there are grandchildren that have joined your family through a second marriage, and it might not be your intent to benefit those grandchildren. So there might be some legal vagueness as to who your grandchildren are. So it might be wise to name your grandchildren individually. And furthermore, if any of your grandchildren are minors under the age of 18, it might be worth considering trusts for those children. And we'll get to that a little later. Or a cash gift, of course, to your favorite charity, $1,000 to ARCs. So the idea here is a bequest is a gift of a specific thing or a specific dollar value to a specific person or institution. Wills do not need to have bequests, but it's entirely an option, but it's worthwhile considering a bequest if you have a specific item, like an object that you want to go to a certain person, or a certain dollar, cash gift that you want to give to extended friends or family members, or to your favorite charity. Bequests are a great way to make that happen. Now, I mentioned earlier that bequests are optional, but what is absolutely mandatory is gifts of residue. So, definition, residue. Residue is what's left in an estate after debts, estate expenses, and bequests are paid. So, let's put ourselves in the shoes of the executor. You're dealing with funeral matters, you're dealing with income taxes, paying off mortgages, paying out the debts of the deceased, paying perhaps the estate accountant with final tax returns, paying legal fees and expenses. Those are all paid first, okay? After that, the executor pays out the bequest. So going back to the earlier slide, perhaps there are gifts of $1,000 to 5 special people. And then what's left in the hands of the executor is what's referred to as residue. Okay, this is essentially cash, net of taxes, net of debts. Perhaps there was a house sale many months ago. All the sale proceeds of that house sale are now in this pile. I'd say on average, an executor probably isn't holding residue until many months after the death, because you can imagine it takes time to close accounts, sell real estate, and what have you, settle debts even, settle taxes, of course, takes time. But once the executor is down to residue, the will should say to that executor who to give that money to. And a will must include this clause. So residual beneficiaries, we use that term. The residual beneficiaries can be family, can be friends, can be charities, or a combination of family, friends, and charities. Now it's important, be mindful. As you may have picked up earlier, these residual beneficiaries are the last beneficiaries to receive. So I'll always like to manage beneficiaries' expectations when I help an executor. Residual beneficiaries might not receive distributions for many, 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 many months after the death. And that's common because the executor is working very hard to administer this estate properly before distributions are made. So residual beneficiaries, I'll give everyone that's listening more insight into me. My affairs are pretty boring, so my residual beneficiary, if I pass away, is my wife. It's common to put a backup plan in a will. So for example, what if my wife is not alive at the time that I pass? Like if she's predeceased me, or if she's passed away at the same time as I do, then I have a backup set of residual beneficiaries, and those are our children. We have 2 children. So my will directs, divide my estate equally between my children. Okay. I mentioned earlier, our children are quite young, so the shares of my children's estate are held in trust, and we'll talk about that in a moment. So key takeaways here: a will must distribute residue. It can be among any people you choose, including family, friends, and charities, and it's normally expressed in shares or percentages, right? So, for example, Before my wife and I had kids, we were considering distributing our collective estate among our siblings, right? I have 2 brothers and a sister. My wife has 2 sisters and a brother. So we were going to consider a distribution among that group. And if any of them are listening today, it was going to be equal. Trusts. I mentioned earlier this concept of a trust. This is a tool that you might want to employ in your will to protect vulnerable beneficiaries. So formal definition, a trust is a relationship where assets are held by one party for the benefit of another. So the terminology here is there's a trustee for the trust and there is a beneficiary or beneficiaries of the trust. I think the simplest trust example is one that comes from my family. Again, if my wife and I pass away at the same time, our collective estate is divided equally between our 2 children and held in trust. So a trust for minor children looks something like this. We're going to ask someone to hold that money for each child. So each child has their own share. There's a trustee named for each of these shares. And the will goes on to say that that money is held in trust until the child reaches the age of 25, at which time the child receives whatever's left in his or her trust in full, single check in one shot. But be mindful, a trust of this nature says that the trustee can use that money for the benefit of the child as the trustee sees fit. So what does that mean? That means that whoever's holding the money for my son and my daughter can apply that money for their education, their wellness, their well-being, clothing, food, housing, whatever they need. The trustee can apply money out of the trust for that child. And that relationship continues until the child reaches 25, at which time the trustee writes a single check for what's left to the child. It might be a lot left, it might be all gone by then. We don't know. The bottom line, though, is that the trust, the will states exactly when the trust ends, and that is by 25 or earlier if the money's all used. So what I described to everyone here is a common trust for simple wills, for simple family circumstances like mine. But it doesn't end there. Sometimes we can use a will to create trusts for an adult child, perhaps an adult child who has special needs and will never be in a position to handle their own money. You can appreciate a trust for an adult child of that nature would not be writing a trust like the ones we have for my family. Again, if we're dealing with an adult child who has special needs and cannot handle money, perhaps their special needs are due to an addiction or mental health concern. This might resonate with some of our participants today. And in that situation, we're going to state in the will that the trust will operate for that child's entire life, because there is really at this point no age that they should receive this sum of money. This money would hurt them, or they might not know how to handle it. So creating a trust of that nature, we have to be very careful, because we're essentially giving the trustee job to someone for the rest of their life, right? So, I mean, it's hard enough for planning for me, because I'm trying to put someone in a role for about 25 years. What if we're putting someone in a trustee role for the rest of their life? Some considerations there, we might want to name some backup trustees to carry the torch further after that first trustee can no longer act. Perhaps we will name, or perhaps we will give the trustee the power to name their successor trustee. So if they want to retire from the job after 25, 30, 40 years as trustee, we can give them the ability to choose their replacement. Another consideration is the possibility of choosing what's called a corporate trustee, or ask a trust company, essentially a division of a bank or financial institution, to do this job. That is a very powerful decision. It's possible to choose a trust company to be a trustee. It's also possible to choose a trust company to be an executor. Didn't mention that earlier, but as we choose executors, if there are no individuals in our lives that we're comfortable with this role of executor or trustee, there are third parties that can do this professional work. I think for the interest of time, I want to move ahead here. I think about 5-10 minutes, we're going to wrap up. I mentioned earlier that preparing your will very much involves choosing beneficiaries of your choosing. Okay, we have something called testamentary freedom. That means that we can choose our beneficiaries as we please. If I want to give everything I want, everything I own to Kirby Center to help with programs, I can do that. I have the freedom to do that. Unfortunately, that causes some issues for my family because I have dependent family members. I have a wife, and our lives are intertwined together financially and personally, and we have children, of course, who depend on me. So what I'm referring to now is a form of a will challenge that a lot of people ask me about. And it's this situation where who are people who can raise their hand and say, I need more from that estate, or I was written out of that will and I deserve a share or a larger share. So these circumstances are circumstances called family maintenance and support. And I know that we might have some people joining us from outside of the province or watching this later on YouTube. It's different terminology in different provinces. It's also known as dependence relief in other provinces. The general idea here is there are people in our lives potentially who have the right to raise their hand and say, I need more from this estate. In front of you here is a list of some of those individuals, namely spouses, common law partners. Here in Alberta, we call them adult interdependent partners, minor children, dependent adult children. Those are adult children who are over the age of 18 and unable to earn a livelihood due to a mental or physical disability. Children under 22 and in full-time education. And of course, minor grandchildren that you're raising as your own. This is a list of people who, again, have a right to raise their hand and say, I need more. Now, this is a very complicated area of estate planning. Do seek advice if this speaks to your family circumstance. We normally see this in the context of blended families. Consider this: a person has a spouse, they're in a second marriage, and they also have children from a first marriage. Maybe they're minor children still. This is a circumstance where this individual has legal obligations flowing to two different families. This is a classic blended family, and in these situations, careful planning must be made to make sure that what's known as proper maintenance and support, basically a fair share of the estate, is provided to the dependent family members. So there's some information here on the slides. I don't want to spend too much time on it because every family is different when it comes to dealing with these circumstances. And again, it's wise to seek legal advice. Finally, a couple slides left here. For those of us who have wills, powers of attorney, and personal directives already, we might be asking ourselves at this point, is it time for me to change my will? Or is it time for me to dust off that document, take a look, because this thing was written in 1996 and life has changed since then? Well, I guess I could say boldly to everyone, if you are looking at a will from 1996, probably good to pick it up. Probably good to pick up a will from maybe even 5 years ago. But there are also in front of us a list of milestones in our lives that might prompt us to pick up that will and take a look. So change in marital circumstances. Again, if you go through a separation or divorce, you probably want to take a look at your will. Bringing in new children or new grandchildren to your family would prompt you to take a look at your will. Disability of a beneficiary. I talked earlier about beneficiaries or people in our lives who might be vulnerable. At the time that you wrote your will, someone in your life, a beneficiary, may not have had a disability, but they may have realized or come to terms with a disability or become injured or or developed a disability later in life. And now your will does not address their disability. Probably the most common reason to change your will is a change of executor. I see this all the time. Someone will bring a will to me. They'll tell me that the will is fine with the exception of their executor. Perhaps that executor has died, moved away, no longer wants to be your executor anymore. That's a very common reason to change your will. A substantial change in assets. Again, if the value of your estate has increased significantly, then perhaps the distribution of your estate is now going to follow a different path. Perhaps the nature of your assets have changed. Maybe you've picked up assets or purchased property outside of the province. I use the word foreign assets. That sounds like an exotic villa in a far off country, but estate and real estate law are provincial in nature. So I want everyone to know that foreign assets can be as simple as a piece of land in Saskatchewan or a cottage in British Columbia for those of us joining us from Alberta. And finally, updating your will sometimes involves tax optimization, finding ways to craft your will in such a way that taxes are reduced on death. I don't have a slide here today about charitable giving, but speaking of tax optimization, one of the key tools, one of the main tools to minimize taxes on death is to include charities in your estate plan. I meet many clients who are driven by that tax benefit and will include charitable giving. But I'd say the majority of clients who are considering charity because they want to leave a legacy. Giving is part of their lives, and they want to make giving part of their passing and part of their legacy. There are ways to engage your surviving family members with the giving through donor advised funds, for example. And again, of course, the tax benefits really are huge, and it's worth looking into. I would recommend that you certainly look at resources online, speak to your tax accountant, and consider speaking with your wills and estates lawyer. With a minute to go, I want to just draw everyone's attention to the two companion documents that come with preparing your will. These are the enduring power of attorney and personal directive. Again, this is the terminology in Alberta. It has a different name in different provinces, but the idea is the same across the country. If you're alive, well, clearly you don't need a will, at least not yet, right? But if you're alive, but in a state where you cannot make decisions on your own, these two documents serve to appoint a decision maker regarding your finances and a decision maker regarding your health care. And those are the two documents there. Enduring power of attorney appoints someone to manage your finances, property, insurance, taxes, anything that's related to your money. The person under this document has power. And finally, the personal directive appoints someone to manage your personal affairs, where you live, what you eat, healthcare, rehabilitation, medication, even end-of-life decisions, and palliative care. And in summary, estate planning involves these three documents: the will, which deals with distribution of your assets on death, and all the decisions we talked about today, and of course, these two important documents, the enduring power of attorney and personal directive, to address a situation where you might not be able to make decisions on your own. So, that said, we're going to wrap up here, at least formally, with our with these slides, and look to questions. Thanks, everyone.
Jonathan, thank you for the great information. That's even gets me thinking that I better have a look at my will and make sure that everything's up to date. I'm sure some of our audience will have some questions for us. So,
yeah.
Jonathan, if you would like to end your screen share. And we've got some questions coming in through Q&A here.
Okay, I'll stopping the share now.
There we go. And then we get to see your beautiful face while you answer the questions. I'm very informative. I think that I learned quite a bit here as well myself, and I'm sure Rob may have some further information that he would like to impart, I think, on the tax optimization side of things. But I've got a question here from Karen Ann. And is it a problem if you leave everything to someone other than a family member? My family does not need anything, and I would like to leave my estate to a friend's daughter who has become almost a daughter to me. What's your opinion on that?
Yeah, great question. Great question. Friends who are family, right? Friends who become family. Great question. Absolutely, right? We have, Karen, you have testamentary freedom to do just that, okay? And you use your will to give that gift. But a few considerations I'll leave with you, right? If you do have any dependent family members, so a spouse, common law partner, minor children, adult children who are unable to earn a livelihood, adult children who are under 22 and in post-secondary, or if you're raising any minor grandchildren, be very careful. You have a legal obligation to maintain them. And you know, giving too much of your estate, so to speak, to this sort of daughter of yours could cause legal issues. But if you're not encumbered by those matters or those members or those types of members of your family, then it's absolutely possible to benefit friends or family or friends that become family.
Ellen, I am single. Can I pass my pension to my nephew?
Thanks for your question, Ellen. This is this is a tough question to answer. The word pension could mean many things. Pension could come in the form, of monthly payments that do not have any death benefits. So sometimes there's really isn't anything to pass on. Sometimes a pension is passed on only to a spouse, and that's cooked right into the pension rules based on that policy. So look into that. But more optimistically speaking, some pensions do allow you to choose a beneficiary, and that beneficiary can be someone other than a spouse. So my short answer is yes, Ellen, it's possible, but I do encourage you to go to your pension provider and make sure that you're able to do that.
Thank you. And Sandy, if you have had a will done in one province, but you move to another, or perhaps the US, can the will be transportable? And she also has another question: can the beneficiary of the will be the executor?
Okay, I'll answer the easy one first. Can a beneficiary of the will be the executor? Absolutely, very common. For example, it's very common for someone who might have 3 children to divide their estate equally among their 3 children, and they'll appoint one of the children to be the executor. Perhaps it's the child who's local, perhaps it's the child that has a good skill set for this type of stuff. So very common to choose an executor and beneficiary as the same person. The trickier questions that you brought for us today, Sandy, is a will done in one province but moved to another province, or perhaps the US. Okay, so if we're dealing with Canada and the United States, a will that's prepared throughout Canada is valid throughout Canada. I don't want to speak specifically to every single US state. Again, estate law is province specific and state specific, but in my experience, I have yet to see a state where a will prepared in Canada is not honored. Okay, so in short, it is transferable, right? If you move out of Alberta, move to another province, it's not like your will suddenly combusted and it doesn't work anymore, right? It still works. But what I want you to consider, Sandy, and anyone else who has this circumstance, is perhaps over the course of the move, your circumstances, or rather your wishes in your will, may have changed, right? So that gives cause to just pick up the will anyway, take a look, because you may want to change it, not because of your geography, but because your circumstances have changed. Obviously, there's been a move, so that might prompt you to change, for example, your executor. Another thing to consider is will planning and estate planning. Again, very province specific and state specific. There are tax implications, and the advice I give a client regarding their will here might be a little bit different than the advice given in British Columbia because of provincial related taxes and fees. So it is worthwhile, I guess here's long-winded answer. It is worthwhile, if you have relocated, to show your will. Sit down with a professional in that new jurisdiction, in that new state, to make sure that it is still in your best interest.
And Sandy has another question, which was something that I had jotted down here to ask. We're on the same wavelength here. One more question: does an executor get paid for from the managing the estate? And if so, how is the fee typically calculated?
Good question, Sandy. Wow, you're not laying off me today, are you? This is all the tricky ones. Okay, so short answer: an executor is entitled to compensation for the time and effort expended in the administration of the estate. This comes from our trustee law here in Alberta, and there are analogous rules across the country. So first thing for everyone to know is an executor is entitled to be paid from the estate assets. The trickier question is how much they're paid. Now, depending on the jurisdiction, there are provinces where there is a schedule of what an executor is paid. It's quite clear as to what they receive. Here in Alberta, it's a little broader. The law does say that an executor is entitled to be paid, but the law does not make it absolutely crystal clear what they're paid. Seems like, Sandy, you know this already. You've said what's typical, and that's essentially what we have to look at when we determine compensation here in Alberta. What is typical? We're guided by some guidelines that are followed and customs that are followed. We see somewhere in the area of 1, 2 to 5% of the gross value of the estate paid to the executor as compensation. Quite a range, 1 to 5, right? Why the range? Because some estate administrations are very simple, some are very complicated and take a long time or take a lot of work. So it's a broad range. It's informed by how complicated the assets were, how difficult the estate administration was, how long it took. It's unfortunate when estates have conflicts, among the beneficiaries and the executor. So that is certainly considered. Was the poor executor dragged into court by a beneficiary who is not pleased? Maybe the beneficiary was right. Maybe the executor did something wrong, and the executor should be disentitled from their compensation. These are questions that go to the court every day. So, sorry, it's a bit of a long answer, but I hope I've given you a general idea.
Would you suggest that that would be something that should be mutually arranged at the time of creating your will?
Great question, Colleen. Yes. So it's possible for all of us, the living, who are preparing our wills, to set out in our wills what the compensation shall be. You can be so bold as saying, I direct that the executor of my estate shall be paid 1.5% of the gross value of my estate. You've set it. You've set what that executor will be paid. That way, the executor isn't in a position to have to choose a number. And what they normally have to do is get consent from the beneficiaries on the proposed number. Kind of awkward. It's like writing your own report card and asking the teacher, is this okay? Right? So by stating the compensation in your will, it serves to mitigate a lot of those conflicts. Good question, Colleen.
Might be helpful. W.K. Farrell, what taxes are to be paid?
Wow, how much time do we have? Kidding, no, it's not that bad. It's not that bad. Okay, so two things to consider, federal and provincial, okay? Two different regimes that have an interest in the estate, so to speak. I'll try to do my very best to talk about taxes in a nutshell, because we're gonna have to have a different day on this. We'll have to check our calendars, Colleen. But the first thing I want everyone to know is that there is no such thing as an estate tax in Canada. There is such a thing in the United States and in other jurisdictions, but in Canada, there is no estate tax formally, right? There's no taxation based on the whole value of our estate, and you're hit with this tax, right? At least federally. What happens is when a person passes away, they are deemed to have sold all of their capital assets the moment they died. All right. So what does that mean in day-to-day language here? If you own a home or real estate, you're deemed to have sold that real estate the moment you died. So if there's a capital gain there, it will be reflected on your final tax return. If you have say a non-registered portfolio of stocks and non-registered investments, you're deemed to have withdrawn all the assets out of that portfolio the day you died. So if there was a capital gain there, then that capital gain will be reflected on your tax return. Here's the one that hurts us all when you hear this. If you have an RSP or a RIF, you're deemed to have withdrawn the entire value of that RSP the day you died. I know, collective silence from everyone. Your executor actually is issued something called a T4 RSP. The entire value of RSP is T4 to your estate. So it reflects as income. So you can imagine all of these capital gains, all of this income is issued or addressed in your final tax return. So no estate tax, but you're treated as if you sold everything on death, and any capital gains, if any, are reflected in your tax return. So that in a nutshell is the federal tax regime. From a provincial standpoint, I'll refer briefly to something called a probate tax. Some provinces have a structure where there is a taxation based on the value of your estate, upwards to 1.5% even. For those joining us here in Alberta, we don't have such a tax regime. There is a single probate fee, which tops off at $525.
Wow. That's good information to know. Anonymous would like to know, if you own land in the US, do you need a separate will in that state?
Wise to stay anonymous. Kidding. Timely. It's election day here. Okay, so my short answer is yes. That is a wise idea. At least seek advice. Bring your Canadian will to an attorney in that state. So say it's California, and that's a state in particular I would recommend. it is wise to put your will to a California attorney and make sure that that will, or your Canadian will be sufficient. It may be, depending on your wishes and depending on a whole bunch of facts that we don't need to review today, it may be that the attorney says, no, your Canadian will is just fine, just keep on living. But they might say, you might want a separate will that deals with your California assets.
Adrienne, what are some third-party executors beside banks, and how do I find them?
Good question. So we were talking about trust companies or corporate executors. This is what Adrienne's concerned with. Most are, or many are associated with banks. Take, for example, TD. TD has a trust group known as the Canada Trust Company, right? RBC has a trust group known as Royal Trust. Bank of Montreal, BMO Trust. The names are very uncreative. But a lot of folks say to me, I don't want to work with a bank. So there are trust companies that are, so to speak, not affiliated with a big bank. Off the top of my head, some of those include Concentra Trust, Sidel Trust. These are institutions, fiduciary trusts. These are institutions that focus on being executors and being trustees. Managing investments is part of their duty, though. So there is sort of a bank element to it, so to speak. But if you want to move away from the big banks, there are options. Thank you.
And I do apologize for the lozenge while we're chatting here, just trying to keep my voice in line today. Sarah would like to know, if your debt outweighs your assets, who's in charge of paying off the debt?
Oh, wow. The short answer is, if the executor's done their job properly, those debts are the problem of the creditors. Okay, your debts are not to be passed on to your executor, and that's a general rule. But there are exceptions. You can probably see the cautiousness in my voice as I give that advice. I guess maybe a short answer first to this. So if an executor does their very best and tries to apply what few assets there are to pay the debts of the deceased, then the executor looks to the creditors and says, there's nothing left, right? I sold everything. I paid the taxes because, if it did the funeral matters, those, modest arrangements, those are the early creditors on an estate. But an executor is completely entitled to say, there is nothing left here. Now, that might be a bit of an uncomfortable experience. If anyone's ever seen bankruptcy or insolvency, it's similar to that process. But that executor is not obligated to pay those debts, and the creditors will just have to take it. That's unfortunately how it operates. I ask this question a lot from the context of, when can an executor have to pay the debts? Well, here's a circumstance. Let's imagine the executor goes in after the passing. They do as good a job as they can at the outset. They gather up estate assets, sell things, start to build up estate assets. And they're getting a lot of pressure from the beneficiaries to receive some distributions, right? These are the residual beneficiaries that, say, for example, split the estate 3 ways. So there's these 3 individuals saying, come on, we need some, we really need some money from the estate. The executor might look to them and say, well, listen, it's early days. I have a tax return that can't be filed until February of next year. And I can't get an accountant lined up to do that until that time. So I need to hold this money in the estate until that time, because I don't know what the deceased is going to owe for final taxes. But those 3 beneficiaries, they run a hard campaign, and the executor, for one reason or another, decides to distribute quite a lot of the estate to these 3 beneficiaries. Well, good, I suppose, for now. They're off the beneficiary's back, or off the executor's back. But here comes tax time. They file the tax return. This is what the executor's doing, and they realize there's quite a lot owing. In fact, so much owing that she or he does not have enough money left in the estate, because they sent it all out to the beneficiaries many months ago because they caved under the pressure. Well, in that situation, the executor can be held personally liable to pay those taxes. Why? Because it was their discretionary decision to give money early to those beneficiaries, and now it's biting them in the butt later. So it's rare, but this really underscores the importance of choosing a good executor, and for those executors out there to be very careful about debts and taxes.
That's one of the things that I think that is a bit of a nightmare for any parent, is worrying about leaving a debt load that their children are going to have to look after for them. So it's I think it's a bit of a relief to know that hopefully that's not as critical for our children as one might think, that they do have some options out. Donna would like to know, in which province does your executor apply for probate when you have property in 2 provinces, for example, Ontario and Alberta? My permanent address is Alberta, but my sons live in Ontario and my will was executed in Ontario.
Good question, Donna. Thank you. And a common narrative, right? Many of us here in Alberta have roots in other provinces. Sometimes those roots are by way of children, right? We have adult children that live out of province. Maybe we come from out of province and our wills were created there, much like Donna's case. I think what's going to drive the answer to this question, Donna, is whether you own real estate in the province of Ontario. Okay. From what I'm seeing here is the fact that you have beneficiaries, or presumably beneficiaries, sons in Ontario, and a will that was prepared in Ontario, that doesn't tell me that you need to apply for probate in Ontario. What's going to drive the need for probate in that province is whether you have a real estate there. Maybe shares of a private company registered in Ontario, that's another possibility. But the main indicator here would be whether you have a real estate there.
Sarah would like to know, if you pass away before your pension comes into effect, how long will that be given out for?
It's a tough question to answer because going back to an earlier question, you have to take a look at the terms of your pension policy, okay? Some pensions just end, and that's it. Upon your death, the pension dies with you. Others are payable to a spouse. Others are what's called commuted to a single dollar value, and a single check is paid to a spouse or a named beneficiary. So I gave you a whole bunch of options, but or possibilities, but you really should check with your pension provider. It changes from policy to policy, person to person.
And El Sava would like to know, should vehicles be in joint names?
Oh, great question. In my experience, it is very handy to have vehicles in joint names between spouses, okay? Husbands and wives and partners. If it's your plan to give everything to your spouse, right, as is in my case for those of us that heard earlier, it would be prudent and simple to keep that asset in joint names. The first slide from earlier today talked about how assets that are held in joint names pass directly to the surviving joint owner. That works quite slick when you're dealing with spouses. There are complications with maybe a senior parent and an adult child being joint owners. We didn't go into that today, maybe on another session. But my short answer, normally it is yes, specifically if we're dealing with spouses.
I'm seeing several names popping up here that I recognize from previous presentations. Thank you all for joining us again. Suzanne would like to know, single at 71 with enough assets to 90s, does it make sense to buy life or health insurance? And can this be transferred to a charity or nephew upon death?
Well, there's 2 parts to the question. Does it make sense? And can it be transferred? The can it be transferred is yes. Yes. There are many types of insurance products, but largely they do give largely they do give you the option to choose a charity or nephew. I do like the idea of thinking about charity. There are some huge benefits there, namely leaving legacy and tax benefits, and nephew, of course, if that's your wish. As to whether it's prudent, I'm going to give a safe answer and say that really is dependent on your personal circumstances, and worthwhile probably speaking with an insurance professional. Not my training, and I probably not best to give an answer there. Thanks, Suzanne.
And Donna, excuse me.
Oh no, you're back.
Donna has mentioned here, you mentioned the jointly owned property and bank accounts would flow to the surviving owner outside of the estate. From a tax optimization perspective, I did create 2 joint TD Waterhouse trading accounts with each of my sons. I thought this would save tax, but I was advised that even a joint account would be subject to deemed sale and my sons would be required to pay tax. What is correct?
There are two ways to see this. I would lean on the side of yes, taxes will have to be paid on death. You see, the idea is, you go back to that tax rule, and I really hope this doesn't take too much time for everyone, but I think this will help you, Donna, and a lot of the participants today. Our taxation system is designed on being taxed when income is generated, right? You make money in a given year as a living person, you've got to file for taxes, and the government will tax you on a portion of your income, right? Canada is very much based on income, taxing income. When you die, you're treated as if you generated income because you were treated as if you sold that entire portfolio. Adding a child as a surviving joint owner and then allowing that asset to pass on to that child on death, you can see how CRA is not pleased with that, because in theory, you can do that forever, right? Keep on passing it from child to child to child to child to child, and no taxes will ever be paid on a death of any of the previous owners. So the short answer is you can see how our tax policy does not allow that. So I would be prepared that taxes would have to be paid. There are situations when maybe it wouldn't happen if this joint account was some form of joint venture, if I can put it that way. If you and your son own this account and you both had money in it, right? Some of your money, Donna, some of your son's money. This is an investment account you're growing together, almost like a venture, like a partnership. Maybe there's something there regarding rolling this over to the son. I have not seen this before personally. I'm really just conceptualizing it. So be prepared. You can tell that I'm not very confident in that likelihood. Most folks are naming their child as a joint owner for convenience only. What am I saying? I'm saying that this account is all the parents' money and the son is only there for succession purposes. And if that's the case, the classic case, then be prepared for tax.
Wow. Maureen would like to know, I have a private signed loan agreement with another party. How does my executor collect the outstanding balance?
Yeah, thanks for your question, Maureen. Good one. Well, generally speaking, look at the concept of an executor. An executor, so to speak, becomes you legally on your death, right? So your executor would stand in your shoes, Maureen, and exercise your rights under that loan agreement. Right? They're going to come in and say, I am Maureen now. I will exercise my rights under this agreement, and I need to collect what Maureen was entitled to. So that's maybe the naive version of it. I mean, that's ideal, but I would encourage you to dig into that private loan agreement and see if there are any terms there that say what happens if you pass away, or if the person you loan money to passes away. Depending on who prepared that agreement, there might be some specifics. You may have contemplated in advance what happens if one of you passes away. What I'm getting at here is maybe your executor's hands are tied. Maybe they're not able to stand in your shoes fully because it's stated in the agreement. So take a look at the agreement. But I guess I can tentatively give you this answer that, you know, something that you were a creditor for, your executor is able to now collect on your behalf, generally speaking.
And we have some flexibility time-wise. We had a little bit of a late start. We've got lots of questions here coming in still. I think that the people are finding value in the information you're giving, so we can extend a little bit here. Donna, hi, Jonathan, me again. I have a house in Calgary and a cottage in Ontario. So real estate in 2 provinces. Does this help in determining which province probate should be applied?
Yes. So I'm going to assume, Donna, that your house in Calgary and cottage in Ontario are in your sole name, okay? Your sole name, just your name alone, not jointly held with one of your sons or spouse. So that being said, the question is, where's probate needed? You're going to love this. Both provinces, okay? Unfortunately, because you reside in Alberta, a grant of probate would be obtained here in Alberta, where you reside usually. That would be obtained first. And then in order for the executor to administer your cottage in Ontario, they would have to go through a process called a resealing of the Alberta probate. So they basically, after getting the Alberta probate is presented to a court in Ontario, and the court now blesses, so to speak, blesses that Alberta probate as effective in Ontario, and now giving power to your executor to deal with your cottage. 2 probates, sorry.
And W.K. Farrell, is probate not necessary if the will is well written?
Oh, good question. Okay. It's a yes and a no. I think the best way to answer this question is to define what probate is. We've used this term a lot. I can see from a lot of the participants today that some of us know a thing or two about probate. But I didn't define it in the presentation, and I think it would be valuable to do that now if we got a moment. So probate, the process of probate involves presenting a valid will, or maybe even a well-written will, to the court to be validated by a justice of our court here, and it confirms the validity of the will, okay? And it formally appoints the executor. It's sort of like a will with a little extra oomph from the court, okay? Now, there is a belief among many that probate is needed when there is a dispute, or probate is needed if you have a poorly written will. Sometimes that is true, but in most cases, probate is needed because there is real estate in the estate. There are bank accounts of a fairly significant size, and that could be anything above even $10,000, $25,000. Getting probate is not a shocking, dramatic, embarrassing event that happens in an estate administration, right? It doesn't mean that the will was written poorly. It doesn't mean that there's a conflict in the estate. It doesn't mean that there's a creditor issue. Probate is an exercise that is done routinely when there is, again, real estate in the estate, or often, bank accounts north of $10,000, $25,000. So you can imagine many, many wills are probated here in the province of Alberta. To speak to the specific question, sometimes a will is not written in accordance with the formalities of preparing a will. What am I saying? Sometimes the will only has one witness. Here in Alberta, you need 2 witnesses if the will is written and or typewritten, for example. Maybe there's vagueness. Maybe the will says, divide equally among my heirs. Oof, it's an ugly phrase. I wouldn't use that, right? So vague words, just not prepared as well as it can be. Probate in that situation can serve to give clarity to that will. So it's a good question. Probate sometimes serves to help these types of wills. This is something I've developed a practice in doing. But again, I think I wanted to use this moment as sort of a public service announcement to not scare people away from what probate is and help people understand what it is.
It kind of opens up the question that I don't think we've addressed today is a will that you prepare yourself or using one of those kits as opposed to using a legal advisor to create one. Is that advisable, or are you just leaving yourself open?
Well, the requirements of a valid will are very, very simple in Alberta, right? Let's start here with something you may have heard of called a holograph will. A holograph will. This is a will that's written entirely in your handwriting, right? Start to finish, signed on a sheet of paper. That is a valid will in Alberta. That simple, right? Or you made reference, Colleen, to will kits, right? Sort of a fill in the blank package, or maybe an online program where you can give information and then it spits out a will. You sign it. You need 2 witnesses. They need to be present at the same time when you sign. So there's a little bit of formality there. It's not rocket science, but just follow the instructions. You'll get it right. That's a valid will too. That's a valid will too, right? Be mindful the witnesses cannot be related to you in certain ways. There's a whole list of things. You can't have your wife be your witness. Anyway, I can go on all day. Bottom line is there are resources out there and ways to prepare a will without a lawyer. You don't need a lawyer to prepare a will. And I want to say that boldly, especially if costs are a concern, or a lot of folks are just not comfortable sharing this information with somebody and they would rather take matters into their own hands. The issue here is, although it's easy to create a will, doing one or preparing one on your own lacks advice. And we talked today about circumstances where you might want to get some opinions, right? Some advice regarding advice regarding maybe taxes, advice regarding a distribution of the estate that might not be equal. And maybe this is going to cause some issues. How do I deal with this? Help choosing an executor. It's all the advice in creating the will is where legal advice provides value. Trust me, it's not for the paper and for the two witnesses. It's for the advice.
Well worth it in the end. Vivian would like to know, would there be taxes to appointed TFSA survivors?
Okay, yeah, I think I know what she's saying. I think Vivian is asking if Vivian, for example, has named a beneficiary of her TFSA or beneficiaries, are there some taxes there? The answer is no, right? Or to be more specific, let's break it down. Vivian, let's say you have a TFSA, there's about $80,000 in there total. And you have named two individuals, say two capable adult children to be your beneficiaries. Upon your death, they can collect $40,000 each. There's no tax withholding. That full TFSA is split into check one, check two. I guess the question is, do they need to pay some taxes? Or maybe the estate of Vivian has to pay taxes? The answer is no. The tax-free savings account, the tax-free feature remains in place even on your death.
And W.K. Farrell, to get a probate validated, do you need a lawyer?
Thanks for your question. I think you're asking, do you need a lawyer to apply for probate? Because the probate application process is a court process. You're applying to the court the local court where the deceased lived. So here in in Calgary, if someone passed away here in the city of Calgary, the executor would be filing an application for a grant of probate in the Calgary courts downtown. You do not need a lawyer to do that, right? The documents are actually available online or available at the courthouse. Many executors take it upon themselves to fill out that paperwork without the assistance of a lawyer. The process of applying for probate can get complicated if the estate circumstances are maybe out of the ordinary, if I could put it that way, or if the will is a bit complicated, or if the will is non-compliant for some reason. It might be wise to get a lawyer to help you through the probate process. I want to share with a lot of participants that the value that lawyers add sometimes has to do with getting a probate application in. We do them a lot, we do them all day, and we've got a good average on getting it done right the first time. But in my view, my obligation isn't to prepare a bunch of paperwork. It's to provide advice over a long estate administration, right? Even the simplest estate administration can take 1.5 years. And although probate is a piece of work that I'll do for the first couple of months of the estate administration, I feel that clients gain most advantage or gain most benefit when I'm giving them advice through the whole estate administration process. So short answer, nah, you don't need a lawyer.
And Anonymous is asking, do you need a witness on a holograph will written at home?
The answer is no. Yeah, but do ensure, right, of course, that the will has to be written from start to finish entirely in your handwriting, right? All it takes is a little bit of typewritten words, extra words added by somebody else, and suddenly we have some problems with that will. Yeah.
Great information. Thank you so much, Jonathan. And one of the things that in the meeting that we had prior to a conversation with one of our colleagues regarding the interest in this area that we're seeing. I've had several messages passed on to me by another colleague, people asking about wills and estates and that kind of information, and particularly from some of our members looking for information on public trustee, guardianships, things like that. I don't know if there's anything there you might like to address, but we discussed the potential of doing some crossover presentations to provide that broad information. Is there anything there that you can address in that vein as far as trustees and guardianships?
Yeah, happy to. So that the area of guardianship and trusteeship is a branch of the state law that we practice in. I personally haven't worked in the area for a number of years, but I have a couple partners who are quite versed in it, and I think perhaps we can reach out to Kirby members in the future. Couple comments. I mean, for those of us that may not know too much about it, very short, guardianship trusteeship 101. You might recall, or the participants might recall, the slide I had regarding power of attorney and personal directive, right? A circumstance where a person is unable to make decisions on their own. Hopefully they've created documents that appoint someone to manage their finances and someone to manage their health care. Now, unfortunately, not everyone has the foresight to prepare these documents. So sometimes someone will become injured, develop a degenerative condition like an advanced dementia, where they cannot make decisions on their own, but they did not create these documents. And under the law, they are now under a disability. They cannot make decisions on their own. So without these documents in place, someone has to apply to the court to become a guardian. That's a person who manages their personal affairs. And someone can apply to the court to become that person's trustee, who can manage their financial matters, even court matters, if they're in a lawsuit, for example. And it's unfortunate when we see these files. We always say to ourselves, oh gosh, if only grandma or if only mom had a power of attorney or a personal directive, we wouldn't be here. But here we are sometimes, and the process is thorough. It's an application to the court. The court has to be convinced that the person before them is the right person and the best person in the whole wide world to be that person's guardian and trustee. And those of us at home can probably appreciate that that's not a simple question for a judge. Mm-hmm. And for all of us, I mean, I guess kind of going back to the will planning side, let's all avoid guardianship and trusteeships by preparing our documents. But for those of us that are in that circumstance for one reason or another, there is a way to do it. You do not need a lawyer to make these applications. Many do seek the advice of a lawyer because it is complicated, but it is not absolutely necessary. And if anyone has any questions, feel free to contact me or my colleagues that do the guardianship trusteeship work.
Conversation we'll delve into with future presentations, perhaps, Rob. Jimmy, I see that you raised your hand here, but unfortunately I can't seem to respond to hand raised. If you have a question, if you'd like to pop it into Q&A quick, we'll just answer a couple more quick questions here. Marnie would like to know, what was the niece or nephew or something like that you mentioned earlier related to estate planning? I think there was a question earlier, and unfortunately it's off our screen now, Marnie.
Yeah, well, I think if it was, we certainly were talking about, through the Q&A, I think a couple times people were asking if a nephew, for example, can be named as a beneficiary. And generally speaking, I said yes, depending on the asset. During my slides, I mentioned, I doubt he's tuned in, but we mentioned my nephew, Isaac, and I talked about him potentially being a beneficiary under my will to receive my entire Coca-Cola bottle collection. So I don't know if that was maybe the question that Marnie tuned in on.
Wait a minute. Not niece or nephew. It sounded like an acronym.
Oh gosh.
I'm not really certain, Marnie, but perhaps if it's something that you think of that you'd like some clarity, you can always perhaps reach out to Jonathan individually. You have had a screen up with your contact information. Do you want to just reiterate that?
Yeah. Shall I put actually, I can share the screen right now for a moment. So there's contact information here.
So if anyone has any further questions of Jonathan, I'm sure that he'd be happy to hear from you. Yep. And Rob, we touched upon today several times regarding tax optimization and charitable leaving legacies and that kind of thing. Is there anything that you would like to address on that side?
Well, what we'd like is, we hope that everyone will consider including a charity in their will. There is significant tax savings and an opportunity to leave a legacy. And we would say that we'd hope that you talk to your financial planner, your accountant, or your estate lawyer about these options, if this is a good option for you. That's what I would say there. And I just want to thank Jonathan for this great presentation and for all the wonderful information. And I want to thank everybody for joining us today. And that we'll have many more presentations on wills and estate planning and financial presentations throughout 2021, and we hope you'll join us.
Absolutely. And a couple of chats here. Jonathan, thank you, Jonathan. This was a very informative session, and thanks to Kirby Center for arranging the Zoom. We've had some people that have had to pop out before the end. Thank you for the awesome, informative presentation. So we really appreciate you being here today, and look forward to working with you again in one of our future presentations coming up, as Rob said, in 2021. I'm going to share a screen here as well. Myself, just to kind of close out. Okay, wanting to make sure that everybody is aware that even with the reduction in numbers here, Kirby Center is open and available to offer all of our critical services for anybody that may need information on information, housing, tax. Our education and recreation are also doing online presentations, as is our Options 45 for older workers. And of course, we've the Elder Abuse Resource Line, and for anyone that is suffering, we're hearing from several people, the isolation leading to depression. And so we invite you that if you have any concerns at all to contact Kirby or go to the Distress Center. The number is indicated there for you. We're here to help you out. And also, in vein of the presentations that we've had this past month, Kirby Center is offering our second flu clinic, and we would encourage everyone to make sure that they get their flu shots. Sorry, I don't think I'm on the full screen here for some reason. There, sorry, I'm going to pop through there. It is by appointment, and we invite you to call the 403-705-3246 to book your appointment for your flu shot. We've learned, particularly this last month, how important it is, and we look forward to having you attend. Coming up, Remembrance Day, we've had to have some minor change to our Kirby Center Remembrance Day service. Typically, we would see 200 to 250 people in our auditorium. And of course, this year we've had to curtail that. So we look forward to kicking off Remembrance Day week here with Valor Canada and a presentation on the soldiers who were from Calgary that were part of the Fighting 10th during the First World War. So I think that that history is going to be incredibly interesting, and we hope that you'll join us for that. Free registration as well on Eventbrite. And then we will be, as I said, we've had to modify our plans that we did just send out, we will at least continue our longstanding tradition of honoring our military and fallen heroes. And we will be doing just a very small private ceremony at Kirby Center, that some readings and some perhaps wreath laying that we will Zoom out, and that can be found, registration for that can be found on Eventbrite as well. And if you would like to participate in our remembrance, our small, very small Remembrance Day service, we welcome you to join us. And our next big presentations going to be November 16th through 20th, Fall Wellness Week. So what we will be doing is featuring some of Calgary's leading providers of information, products, and services to present their businesses and their products and their information virtually. So beginning on Monday, November 16th, each day we will be doing presentations. And again, for this, we're suggesting that you go to www.kirbycenter.com, where you'll find the links to register on Eventbrite for each of those presentations. We hope that you'll join us for any one of them or all of them, and we look forward to seeing you there. And then we do have another presentation in December, retirement in a volatile market, as part of our ongoing financial planning presentations. And today, Jonathan, thank you so much again for all of this very valuable information. It was wonderful, and it was also nice. It's a topic that's not always, as friendly as you know, one would like to doesn't really want to have to think about these kinds of things, but you made it very enjoyable and very interesting. And so we appreciate you being here. And thank you to everyone who has joined us today as well. And again, if you have any further questions, by all means, reach out to Jonathan. A couple more accolades here. Excellent presentation. Thank you so much for your help. Well organized. My questions were answered. So on that note, I think that we can probably call this a wrap today. And Rob, thank you. Nice to see your face again.
Yeah, you bet. Thank you, Jonathan. Thank you, Colleen. And thank you to everyone that attended today.
Absolutely. And we'll look forward to seeing you again very soon.
That's right.
Thank you,
Jonathan.
everyone.
Thank you both. Stay well, everyone.
Yeah.
Absolutely. And you as well. Bye-bye.